Hi, everyone. Welcome to the Refugee Law Laboratory's latest seminar. It's nice to see many of you here, in spite of the time of the year. I know it's a challenge to get people out in the last couple of weeks of the summer, so thank you very much for joining us. For those of you who don't know me, I'm Sean Rehag. I am the director of the Refugee Law Laboratory. I'm also an associate professor at Osgoode Law School. And when I'm not on sabbatical, as I am this year, I'm also the director of York University's Center for Refugee Studies. So I'm delighted to introduce today's seminar. And one of the reasons I'm delighted about that is because the Refugee Law Lab has been thinking about how we can use machine learning tools to advance some of our research. And in particular, how can we use machine learning tools on data sets that involve legal data? It might be dockets, it might be court decisions, so legal data that involve refugee law. And one of the challenges that we've encountered in trying to do that is that there aren't very many good open source models that are pre-trained on legal data that include Canadian case law. And so for an organization that's primarily although not exclusively interested in refugee law and migration law as it's interpreted and implied in Canada, this poses a challenge for us. And so we were very pleased to see over the summer that there is a new model that has been developed that actually does do some of this pre-training on legal data. And my understanding is that it includes some Canadian legal data in the training data that they used. So I was keen to hear a little bit more about this data set, about the model, and about what researchers might do with the model. And so that's why I have convened you all here over the summer to hear about this research. So as you know, our speaker today is Peter Henderson. Peter is a busy person. He is doing his PhD in computer science at Stanford University, and because that's not enough, at the same time he is completing his JD at Stanford Law School. He's also an OpenPhilanthropy AI Fellow, graduate student fellow at the Regulation, Evaluation, and Governance Lab, and a technical advisor at the Institute for Security and Technology. And he's going to be speaking to us today about his research called Pile of Law, Learning Responsible Data Filtering from the Law and a 250 gigabyte open source legal data set. So we're going to hear from Peter for about 25 minutes or so. Then we're going to have a discussant, Simon Wallace, who I will introduce just before he speaks. And then we'll have some time for Q&A, and the plan is to finish by 2 p.m. Toronto time. So Peter, welcome. We're looking forward to hearing about your research.
Thanks so much. Let me go ahead and share my screen. Just let me know if you can't see it, but I'll just assume that you can. So thanks so much for having me today, and I'm excited to talk about this work. This work is done with a bunch of wonderful co-authors that are up here on the screen. It's very much an interdisciplinary and collaborative effort. We have lawyers, political scientists, computer scientists, linguists, what have you on the team. So it was great to work on this. And I should say none of the views here are of any other government agency, company, entity, or other person. They're all my own. So just a quick disclaimer on that. So I wanted to talk to you about Pile of Law, and there's a lot of AI out there right now that can do a lot of wonderful things, and it's really important to think about both the data side and the application side. And as an example of the capabilities that we're getting to, here's for example, I just did this right before the talk. This is a an AI model rendering what it thinks pile of law is. So we have some gibberish, on the books, but otherwise starts to, it's starting to look pretty good. So we're really improving the capabilities of these models quickly. And so when you think about pre-trained models and the type of machine learning models, I want to give a little bit of intro in case, folks aren't familiar. Basically, what happens is you take a bunch of data, you train on this data with no supervision signal, right? So it's just purely trying to predict sort of the next words, the next image, the next sounds from the previous text or image or sounds. And so using that process, you can actually encode a lot of information into a neural network, and then you can adapt that to downstream tasks, like question answering, like image generation, like I just showed you. And then you can think about other applications, healthcare, law, which is important to us here, and education are some. And this is from a different paper that is linked here, but basically it is sort of an overview of these types of models. So mostly I'm going to focus on the data with an eye towards legal applications today. So let's talk about the data that goes into these models. So commonly for the existing models, what happens is they take a snapshot of the internet, something like Common Crawl. Common Crawl is basically just a web crawler over the internet. It indexes everything, and then you train a model on like a very large portion of the internet. The problem is anything that goes that's in the internet will also go into the model, and then downstream anything that's in the model can come out of the model. And so many have found that there's offensive content in there, for example, anti-Muslim content. There is private information that can be encoded. The internet is not exactly the most filtered place on the planet. So there's a lot of content in there that might go into the model that you don't necessarily want to come out of it later on. And so you sort of have two choices when you want to prevent things from going into the model when you're training at that scale. You can do differential privacy, which the US Census Bureau tried to do, and is now, there's a whole problem with that. And so, but really model creators haven't focused on this. So, and it's very much a research question right now. So I'm not going to really talk about this. Instead, I'm going to focus on data filtering. So when you think about data filtering, it's basically, you want to prevent anything that you don't want the model to know from going into the model. So you need to figure out what content you want to remove from your data set. And so we did a little, mini examination of different data sets used for pre-training models and different models that have been trained and what kind of filtering they do. And they do a lot of filtering for sort of low quality content, as well as toxic content. So they'll filter out profanity, they might filter out hate speech, things like that, based on these off-the-shelf models. And then very few of them actually filter for private content, which we'll get back to. But you can see here that it's basically every research group for themselves, right? Like they figure out what they think is important to filter out, they make those decisions. And a big question is, how can we make this ad hoc filtering that is basically group by group a bit more participatory? And we thought, what about the law? Because there are already sort of participatory systems. Of course, many of us would like them to be more participatory, but certainly they're more participatory than individual research groups making their own decisions. So, and in, quote unquote, the law, which I will, broadly refer to, agencies, courts, things that have sort of legal norms behind them. And those entities have had to deal with these transparency versus privacy trade-offs repeatedly throughout history, and they've developed norms, they've developed laws to handle these trade-offs. Obviously, those are evolving. I think very recently, we saw that even in Canada right now, that is evolving, how we handle that transparency. And now their courts are considering allowing commercial entities to republish data as well. So certainly things are evolving in this transparency versus privacy trade-off, but there have been sort of norms put in place already. And so when we think about norms, especially in terms of privacy and legal standards, you can think about courts, for example, having different sealing standards or pseudonymity standards. And all those standards trade off the private information that is released and the potential harms from that versus the need for public transparency. And so transparency and openness is key to fighting corruption and ensuring fairness, things like that. And then you have to balance those against the privacy interests. And this is very much similar to the trade-offs in what we might think about putting into a model, right? We want the model to be the most informed, the best it can be, but we also want to respect those privacy harms. And so one way the court has done this, for example, in the Executive Office of Immigration Review in the US, is to look at pseudonyms, right? So EOR, as I'll call it, has a different standard for pseudonymity. So some presidential opinions that they release are under these sort of pseudonyms where it's just using the initials of the respondent, and others use their full name. And this is a very contextualized standard. And what we realize is that the courts and agencies, both in Canada and in the US, have very contextualized standards for how they filter names and other private content. So they'll very much look to what is the underlying fact pattern, what is the potential harm, and think about those situations when they decide whether to use a pseudonym, whether to redact something, whether to seal something. But that's very much different than what we do for language models, right? So when we do filter content, often it is via word lists or simple, very much not contextualized rules that determine what goes into the model and what comes out. And really, as I mentioned before, very little private content is actually filtered out before training a model on it. And to give an example, so I fed the exact case number as before in this slide into GPT-3, and it sort of made up somebody's name. I don't know if this person is real. I censored the full name. And then it just sort of made up a case opinion and wrote it out as if it's the real thing, right? So, and you can imagine in very sensitive contexts, if this person is real, they would certainly not want the model to pick up their name and spit it out in this particular context, right? So it's not really clear if the generated content is safe. People's names might be associated with information that might lead to safety harms. For example, if they were seeking asylum and they're testifying about particular things that happened to them, you might not want the model to simply learn that and then start spitting it out all over the place. Of course, this information would have had to be on the web already, but some of it is harder to find. It might be de-indexed. We don't know why it's on the internet. The internet isn't, like I mentioned, isn't the most well-filtered place. And so really it's important to think about what kind of context and contextualized decisions we want to make about filtering content, just like the courts do. But at the same time, we can't just filter, in a rote fashion, right? We can't just remove all names. For example, you want the model to know, for example, important case names, if you're applying it to a legal context, or even for simple QA, you want it to know, for example, who's the president of the United States in 2016, or sorry, in 2015. And if you remove all names, it will just say, I don't know. But you don't want it to say, I don't know, you want it to say, Barack Obama was the president at that time. And so really you need a very contextualized perspective, just like the court does in terms of what you redact before you feed it into a model. And the law can actually teach us something kind of imperfectly. So the law, across different court systems, we have a Canadian audience here, so I'll focus on the Canadian one. So for example, youth criminal records are always confidential, right? In the US, you might, there's sort of a baseline standard of you need to remove date of birth, social security numbers, addresses, things like that. And then everything beyond that is contextualized. There are, different ceiling standards, both in the US and in Canada. But Germany takes a very different approach. They redact all identifying information, all names. And so really this can be, a jurisdiction by jurisdiction perspective. And we have a number of these in the data set that I'm about to tell you about. But we can think of the US as, the US is probably the most transparent and the most biased towards releasing information. And so you can think of that as maybe a minimal standard, where really at the minimum you want to redact sort of ID numbers, social security numbers, things like that. And beyond that, you want to think about these contextualized redaction mechanisms. Canada is somewhat similar, though somewhat less of a bias towards release of information than the US. And so what we did is we collected a very large data set of legal information. And the idea behind this is both to investigate these sort of privacy and later I'll talk about toxicity standards, as well as aggregate data so that we can train models on it for legal context, because as has been talked about earlier, it's really important to try to use these models to bring social good to the world instead of purely just for fun training them. We want them to actually bring benefit. And so it's important for us, at least, to train things within the legal domain and try to tackle really hard legal problems that can actually help lawyers, help their clients, and bring social benefit. And so we have a very wide range of sources here, both intended to investigate these sort of privacy toxicity filtering standards, but also just laws and other regulations that might be useful to know. And for this audience, we have a fairly modest subset of Canadian court opinions compared to sort of the other subsets, but we have Ontario and BC Court of Appeals in here. And so for each of these, we sort of also provide a breakdown of what are the filtering norms that go into each of these subsets. So again, for example, for the US opinions, the Federal Rules of Civil Procedure require that you redact, for example, social security numbers. And so we have those for each subset. And then we did a little experiment. Recall that for the Executive Office of Immigration Review, there's this contextualized pseudonymity standard, right? You want to determine what contexts the agency decides you should not reveal somebody's name. And so what we did is we created a smaller data set where we masked references to the respondent. For example, the respondent would be replaced with a mask. And then we asked the model to predict whether the court would require pseudonymity in this context. And the model's online, so you can actually try it out. Sorry, it might be playing audio, but okay. But basically here, this is showing that if you input just, mask as a software engineer at Stanford, it will predict no pseudonymity. And then if you add who experienced torture and is seeking asylum, it will say you need a pseudonym, because that's sort of the standard that the court uses in the Executive Office of Immigration Review. And the model actually learned that from the data, that these are the sorts of contexts where you might want to pseudonymize the sentence or the passage, or filter it out from the data, right? So you might not want somebody who experienced these sorts of things, as seeking asylum, to have their name encoded in the model. And so it's really important to think about how courts apply these standards and how we can think about filtering content more broadly before feeding them into models. And I'll also talk a little bit about toxicity filtering. So for example, you might not want the model to learn anti-Muslim things, like it was found that has been picked up in existing models. And so a very basic thing you might do is you might want to try to detect that content and remove it from the data so the model can never learn about it. And so there's a lot of off-the-shelf tools that allow you to detect some of this content, but as I will talk about, that's very difficult to do in the legal context. And just to be clear, we probably do want content to be filtered. The courts do have implicit filtering of this content already, right? If we're trying to mimic court standards and learn from sort of this, the filtering standards of agencies and courts, we would filter content, right? Epithets are not acceptable. There's a bunch of different cases of sanctions being filed or disciplinary action and even disbarment for attorneys and judges that use epithets directly. And so we really, even if we're mimicking the court standards, we would filter this content. And obviously we want to do a little bit better than that. And so the difference being, however, that courts will allow mentions or quotes. So if you're quoting offensive language in an opinion, that is okay. If it's, we haven't seen cases where that's a problem. And so that's going to be a little bit problematic, as we will see. And so there's three problems with trying to filter things off the shelf using these off the shelf models. Problem one is the filters often disagree, and picking one makes a sort of value judgment. And so we tried 4 off-the-shelf filters, and we found that, for example, they really agree very little, and they start to agree more as you come closer to modern times, right? So as you go toward 2000, they start to agree a little bit more, and this is related to the training data of the filters themselves. They're trained on non-legal language. They're trained on social media type of contexts, right? So as we move towards modern type of language, that comes closer to the distribution that they're trained on, so they might tend to agree a little bit more. But even then, they agree very little. And so, and even sort of more problematic is sometimes they will filter important cases. So here you can see that they filter civil rights cases in the 1950s, 1960s, which are very important cases to know if you're trying to train a model on legal context, right? So it might be important to have the sort of toxic law so that you know that that sort of law is unacceptable, right? And so you might not want to filter that toxic law because you're simply quoting it to say this law should not be, is not constitutional, should be overturned. And, for example, here we have Loving v. Virginia, which famously overturned bans on interracial marriage in the United States. And it obviously flags the law itself as toxic, correctly so. But if you remove that, a model trained on it might end up not understanding what about the law was so problematic, right? And so that's an important thing to keep in mind. And then even worse, we can make the models flag things as non-toxic simply just by adding a few extra sentences around a toxic sentence. And so we found that the models basically almost very rarely will flag something as toxic if you just add a couple sentences on both sides of a toxic span. We have some examples in the appendix of the paper. I will warn you that they are offensive because courts in the past have said offensive things. And so, there's a content warning there, but you can check it out. We basically found that you can turn any offensive span of text that a court may have quoted or may have said into something that is flagged as non-toxic simply by adding a few sentences around it. And so these toxicity filtering models are have a lot of nuance to them, and it's really important to keep in mind how that nuance will seep into any data that you filter with them. So especially in the legal context, there's really more, it's necessary to research more in this area, think about how to handle these more complicated toxicity filtering settings. And so now I'm going to quickly talk about the actual legal tasks. So a lot of the paper is focused on data filtering because we felt that the machine learning community had things to learn from the law side of things, from the law in how we filter for these the data for these models. And so we focus mainly on that for the machine learning community, but I know this audience is also interested in legal tasks. So I will very briefly talk about the difficulties in applying machine learning to legal tasks and why we might care about that. And so why do we care? So first, these models are able to make a lot of connections and find patterns in data really well. And so how does that help us as attorneys or people who may be interested in social justice or just simply making legal work a little bit easier? So ideally in the future, you can imagine that these models might be used to, for example, check legal opinions for errors. This is already sort of being done in federal agencies a little bit. For example, the Social Security Administration has a model that checks opinions for very basic errors. It just classifies, for example, if the opinion does not address a claim that the claimant made. But we can imagine that these systems might become more complicated, might be able to handle more complex reasoning sort of abilities so that they can check opinions or briefs for errors more robustly. And we might want them to automate simple tasks that really should be automated, sort of basic things in formatting and research. And then you might want them to analyze data to check for harmful or helpful trends. For example, like we do here, we analyze the data to figure out what is the sort of contextualized standard for pseudonymity in the immigration courts. But these are really hard challenges for ML systems, right? So if you think about legal reasoning, oftentimes you might have to do analogical reasoning, so applying a rule to a fact pattern. And as I'll show you in the next slide, these systems are not very good at that. You often have to parse really long documents. And there was a paper that came out a few weeks ago that showed the models, you can modify current models to handle the long document context, but then they might do things like hallucinate facts. So if you ask, for example, to summarize 200 pages of court dockets, what it might do is it might get all the facts wrong, but it'll sort of give you a relatively coherent looking summary, but actually got the important details wrong. And so we have a lot of work to do to smooth out these problems before they're really useful. And often you have to do multi-step reasoning. You have to go find the evidence, figure out, okay, how does this evidence apply for this rule? Okay, let me find the other piece of evidence that creates a chain of reasoning that helps me in this case, right? And so these are really complicated ML challenges, but to my mind, sets a really great goal for machine learning research, right? Because if you can solve these challenges, you've really solved a lot of hard ML problems that get you towards sort of generalized abilities in ML systems. And so I think this is a really good challenge for people to work on. And a big part of the reason why we aggregated this data to encourage ML researchers to to sort of focus on these tasks. And so a good example of one of these failures is from a different paper. We showed that, for example, if you give it a contract dispute and you say, there's a contract that says I have to pay $1 million if I damage a Toyota Corolla. And reminder that liquidated damages clauses are not enforced unless the sum stipulated is exorbitant or unconscionable. And so, or sorry, they are enforced unless the sum is stipulated as exorbitant or unconscionable. And so, is Y entitled to damages? If so, what amount? The model answers yes, because $1 million for a Toyota Corolla is not exorbitant, right? And so, but we all know that that's not logical, right? This is not a good application of analogical reasoning. And so it requires this sort of multi-step logic that these models aren't particularly good at, though we are working on it and trying to improve that. And so we hope that Pile of Law, which is our data set that we gathered, can help investigate training of these foundation models to improve the status quo. We did train a small model, relatively speaking, on the data. We had limited access to compute, so we believe the model can be improved. It's probably a little bit undertrained, but nonetheless seems to perform pretty well in at least one legal task, which is sort of a particular type of test that I won't get into for the sake of time, but basically it seems to help a little bit in that. But we think further training with more compute can do better, and we hope that we encourage people to try out different training mechanisms in this data to really improve the state of the art in terms of legal reasoning, so that we can use them for things that might be interesting, for example, to the Refugee Lab. And so we hope that this data set is useful, and we'll encourage more research in this area. So thank you so much, and feel free to reach out, and I'm sure we'll have some time for questions here as well. Thanks.
Great, thanks so much for that, Peter. I have all sorts of questions, but I know Simon does as well, so I'm going to introduce him. So Simon Wallace is a doctoral student here at York University's Osgoode Hall Law School. He's also a research lawyer with the Refugee Law Laboratory. He has several years of practice as an immigration and refugee lawyer representing non-citizens at all levels of Canada's refugee and immigration systems. And he's been spending the last several months thinking very carefully about how we can use some of the kinds of techniques that Peter's told us about today in the specific context of Canadian refugee adjudication. So Simon, about 5 to 10 minutes for you.
Thanks. I'll be closer to 5. So I wanted to begin, Peter, just by congratulating you for the work. As soon as I saw Pile of Law, I was convinced, and I think everything I've read since then, convinced that Pile of Law is going to be sort of one of these markers that everyone's going to talk about sort of before and after in legal NLP. And I think that it's just going to be this, its release is going to be a very important moment for the field and the research community. I just wanted to sort of touch on 4 points to get the conversation going, and then we'll see where it goes, because as Sean says, I do have lots of questions, and I think the work is really very exciting. I wanted to begin, though, just by talking about the scale of the data set, and invite you to talk through a bit more ways that the scale can help us or can be maybe a problem as we develop legal NLP tasks. So one thing that the scale of Pile of Law, so 256 gigabytes of law, that it strikes me with is that it could create a number of confused outcomes. That if you were to train, as you did, an entire model on all of the law, it's going to incorporate a number of different norms. As you pointed to, that privacy norms in Canada and Germany and the United States are sometimes different. Similarly, across all 50 states, we're going to have different norms, different ideas, and different laws. And I wonder to what extent, like I can see advantages to drawing on so much, but I can see disadvantages too. In the paper, you allude to the fact that there may be some tasks, some cases where it's better to train on a narrow set of data as opposed to the whole thing. And I wonder if I can invite you to reflect on that a bit more and tell us a bit about your thinking with that. In particular, I noticed as you were speaking that one of the things in Pile of Law is the bar exam materials. And I wonder if there are some types of law which may be more amenable to training. For example, with the bar exam, where everything's sort of consolidated already, the conflict is pushed out, there's given sort of a clear idea of what law may be, whether that may sort of be a more useful foundation for some NLP tasks. Because as a lawyer, when I look at the common law, and maybe my view on this is empirically wrong, but as a lawyer, I look at it and I just see judges disagreeing about things all the time and parties disagreeing about things all the time, and to what extent that may manifest. A related question, and we spoke about this briefly before we came online, is to what extent this is a valuable historical resource, and to what extent we can mobilize ML techniques to learn things about, in your case, in this research, how privacy norms have changed over time. When we have all of this data, have you sort of thought through ways that we can empirically analyze it and see whether there are things have changed over time, whether there have been convergences across different jurisdictions? I know this is sort of separate and apart from it, but just to see all of this data in one place makes me wonder about that and wonder if that's something you've thought about. I'm glad that you took us to legal reasoning at the end, because it's been one of, I'm really interested in it, and watching GPT-3 hallucinate incredible things as I do research has been maddening and fascinating. And I'll get excited about something and think I've discovered GPT-3 doing something really interesting, and then I go compare the source document with what it's done, and I found it's just got everything wrong. I was working on one project where I asked GPT-3 to summarize 10,000 cases or something, and maybe in 10% of them, it just came up with the most fantastical stories, which is sort of was disappointing but interesting at the same time. So sorry, that was a segue. To that end, though, how do you envision Pile of Law being something like, and I'm sort of tuned to the scale question, something that we can use to develop specific and useful tasks? So as I say with the scale question, do you think that there's a more profitable future scaling down Pile of Law for models, or scaling up and drawing on more and more and more to make successful and useful legal task research? And finally, accessibility. So you're a computer scientist and a lawyer, and most of us aren't. I wonder if you could talk a little bit about where you see the research going and maybe democratizing. Definitely, AI tools are much more in reach for a lot of us compared to a few years ago. But as someone who is a professional computer scientist as well, I wonder if you can speak a little bit about how you see the field developing and how more traditional legal scholars and lawyers will be able to connect with and interface with some of the machine learning and AI research that's coming out now. So, four somewhat scattered thoughts, but I invite you to respond to anything that you find particularly interesting or not.
Yeah, thanks so much for those wonderful thoughts and very kind words. So I'll try to go in order, but I might have to ask you to refresh my memories as I go through. And so I think point one was about scale. So do we want large data and large models versus maybe narrowing down the data and having smaller models for the various subsets? I think the research we have seen so far suggests that narrowing down to a particular domain with a smaller model appears to help more. We were able to match performance in one domain for a small model with a larger model that's trained on a wider variety of data, but what we have seen in subsequent research since our work was submitted and put out in like the last few weeks already, we see a lot. ML is a very fast moving field, and so we learn a lot in the weeks after. And so what we found is or what others have found is that scale, both in terms of data and in terms of model size, up to a point, should help break through these sort of should basically help. I'm trying to translate this from the ML vocabulary to something a little bit more accessible. So basically, at some point, there's a breakthrough region where we think that the models learn to do more complicated reasoning internally within the neural network. And that seems to happen at both scale of model size, so model parameters, the number of neurons in the network, but also scale in terms of data, right? So there was a paper that came out maybe earlier this week that seems to suggest that around 7 billion parameters and with a larger amount of data, what you see is more representations that do more complicated types of reasoning. And so that's why I think scale, versus both in terms of data and model size, is probably important to handle some of the more complicated types of tasks that we want the models to do. Now, of course, for very simple types of tasks that you think you can do without sort of multi-step reasoning, without more complicated logic, yes, it's probably important to narrow down the model size and the data to your very particular setting. The model that the SSA uses, the Social Security Administration, for identifying errors, I don't believe is very complicated, right? Because you can sort of check very easily if if a claimant wrote about a particular type of claim and you just never address that claim, that's a very sort of simple task. You should see some text that looks like the thing that was claimed in your opinion, but if you don't see that, it's a very sort of simple mapping problem. In terms of the different standards that are in the data, both legally and sort of privacy-oriented standards, of course, that's going to be, the model will pick up a lot of different things. It might learn to hallucinate different things. And that's why it's important to tune it. So at the beginning of sort of the slides, I showed that, you train this, what we call a foundation model. You can call it a pre-trained model or whatever you want to call it. But you train this model and then you adapt it to your setting, right? So you try to instill these sort of higher level reasoning abilities or a basic knowledge base into the model, and then you adapt it to the context and you say, well actually I'm in this particular legal domain, use what you can from these other contexts. For example, transferring from criminal law to contracts is a very big jump. But there are basic abilities that we might want each of, the model to learn that are just basic sort of reasoning, basic language skills, that having both of those together would be useful. And then you sort of adapt it to the actual context that you care about. And so you try to retain the generalized abilities from both and then adapt it down the line. And in terms of like bar exam, and I think we have Reddit in there as well, Reddit legal advice. Those we included specifically because they're sort of more simplified language, right? And we felt that, one thing that you see with, for example, GPT-3 is that it is able to do a wide variety of tasks with very little tweaks, even if it messes up a lot of the time. But part of the reason it's able to do that is because it has seen these different types of contexts, right? Like if the model only sees legal opinions, it's only going to be able to do, adapt to sort of legal opinion type settings. And oftentimes what you might want a pre-trained model to do is sort of be able to answer questions, right? And if it's never seen question answering, it won't be able to really do it, right? So that's part of the motivation for including some of that simplified language. And then in terms of, I guess I'll jump around and circle back. In terms of accessibility, I think what we're seeing with models like GPT-3 is that they are becoming more accessible because you don't need to program to get the model to do things in a few shot manner, right? So you can just give it a few examples, right? You can say, here's what question answering looks like. I want you to do this, but for the legal domain, right? And some of the follow-up work for GPT-3, what that they've been trying to do is something called instruct GPT, which is you then further tune it based on human feedback. And so the humans say like, hey, you didn't really do the task that I wanted you to do, or you did something really wrong there. And you sort of update the model to be more aligned with what humans expect when you give it an instruction. So you can give it an instruction like, write this sentence in the style of a law review article in a top law journal, right? And you might want it to transfer your very simple language into this flowery law review style that's going to get you accepted to the top law review. And so it needs to understand how to do those things. And as it's better able to understand those things, it becomes more accessible and more democratized because you don't need a PhD in computer science to get the model to do things that you want it to do, right? So I think that's sort of the path towards democratization of these tools. But certainly there are others as well. I think open data, open models are really important because if they're in closed source ecosystems, it's very difficult to probe what the model's doing, figure out what, why it's doing things wrong or fixing them. And so I think there's a lot of different pathways there. And I'm gonna ask you to remind me of or prompt me for the other two. Like I mentioned, I kind of lost track of them.
That's what, maybe, and just sensitive time, maybe this would be a good time, Sean, to invite questions then. And
great. Okay, well, our practice at the Refugee Law Lab is just to record the presentation and any discussant. So I'm going to end the recording now.